We will move to the fourth case on our docket. Ginsberg-Klemmt and Sarasota County. Yeah, for demonstrative aids, I approved it. So that in case you want to see in a big blow up, everybody can see in a little bit. That'll enhance the presentation, and they're all in the record. That's fine. You know. Good morning. Still morning. Were you here earlier when we started, or did you just come in?
I was here. I signed up, but I only actually came in after the program.
Okay. I'll let you do that, then I'll make sure you know how this works.
Okay.
Because you are the appellant, you have a right to reserve a portion of your 20 minutes for rebuttal, up to 5 minutes. I'm your timekeeper, and I'll let you know when you get to that point. So when you start your presentation, you should let me know how much time you like to reserve so I can keep track for you.
Very good, Your Honor.
Okay, thank you.
Thank you. May it please the court, my name is Erika Ginsberg-Klemmt from Sarasota County. I will respectfully request 3 minutes for rebuttal.
Thank you.
According to the Florida Constitution, Article 5, Section 20, Paragraph 3, circuit courts shall have jurisdiction on all actions involving titles or boundaries or rights of possession of real property. Furthermore, Section 26.0122G, Florida statutes, provides that circuit courts shall have exclusive original jurisdiction in all actions involving the titles and boundaries of real property. So today we're going to be respectfully requesting that you reverse the circuit court's order granting Sarasota County's motion to dismiss 2 counts of our 3-count declaratory judgment and to remand the matter to the lower court so we can proceed with the boundary dispute which has never been litigated. The narrow and specific issues of those 2 counts regard the ownership and control of private property owned in fee simple and located on Siesta Key Circle in Sarasota County. In December of 2015, the Sarasota County Commissioners, acting as the Water and Navigation Control Authority, upheld the denial of a dock building permit. The denial was based in part on the lack of space for 2 vehicles on our property outside of the public right-of-way. This lack of parking space is due, again in part, to the county's stance that the right-of-way at the cul-de-sac would have a 50-foot versus a recorded 30-foot radius. Our professional survey, basing his assertions on the recorded subdivision plot, showed the 30-foot public right-of-way radius at the terminus of the cul-de-sac. 8 months after we had applied for that building permit for the dock on the property, the county came up with a different survey showing a 50-foot radius. It is our position that the county based their survey on an undated, unrecorded, unsigned, and unoriginal so-called calc sheet. So this discrepancy, this boundary dispute that you see here in the Sarasota County's overlay exhibit provided by the WNCA for the denial of our dock permit is the sole subject of the first 2 counts of our declaratory judgment action, of which the second count is based on the Marketable Record Title Act, or MRTA, and is closely and inextricably linked with that first count. We unfortunately are not here to litigate that 30-foot versus 50-foot radius. We are here to defend our right to litigate our property boundary dispute at all. county alleges administrative res judicata, collateral attack, splitting cause of action, and failure to state a cause of action. I would like to bring to your attention a 2007 case of Ronald Hartman versus Sarasota County. This can be found on page 12 of my initial brief. This lower court decision shows that it's not the first time Sarasota County has attempted similar tactics as the one they will be arguing today. Sarasota County Attorney Pierce has unsuccessfully attempted to bar a citizen from simultaneously filing a declaratory judgment and a writ of certiorari, using similar argumentation as in the present case. Attorney Pierce wrote in his motion to dismiss, quote, "Because this court has already correctly exercised jurisdiction over this dispute in a certiorari proceeding, and a landowner's traditional remedies have been subsumed through such proceedings, the Hartmans have failed to state a cause of action for relief. Accordingly, this court should dismiss the Hartmans' complaint with prejudice." Well, Judge Lee Hayworth did nothing of the sort. He denied that motion to dismiss and ordered the county to reply within 10 days. Our case was another opportunity for the county to try and allege collateral attack, but this time the judge concurred. The final order we are appealing, which reflected the county's proposed final order verbatim, specifies the following, quote, "As a result of pursuing administrative appeal and subsequent certiorari review, plaintiffs cannot seek declaratory relief for the same issues here. See Gagnon versus Board of Trustees." So this Gagnon case law is written into that final order. The county's case seems to rest squarely on Gagnon versus Board of Trustees, which the county is construing to imply that a citizen could somehow seek administrative remedy to adjudicate boundary disputes. Let's talk about the Gagnon case for a moment. The Gagnon case focuses on whether the Department of Environmental Protection administrative body can issue quitclaim deeds for lands that had been filled pursuant to the Butler Act. So the Gagnon case is impertinent, inapplicable, and completely distinct from our case. In Gagnon, the court concluded that, quote, "A quiet title action in the circuit court and an administrative application under Rule 18-21.019 are alternative remedies available to the landowner." So let's turn to Rule 18-21.019, which provides for the trustees to issue disclaimers of state ownership to submerged lands to all persons who can establish title to such lands pursuant to the Butler Act. The Butler Act encouraged waterfront owners to obtain title to submerged lands adjacent to their uplands by bulkheading, filling, or permanently improving the submerged lands. This Butler Act, by the way, was repealed by implication in 1951. It was expressly removed in 1957, and the Butler Act continues to affect the title to submerged lands that were so improved prior to that repeal. Ours is not a case of submerged lands that were filled pursuant to the Butler Act. We do not have that remedy available to us that Gagnon had. By applying relevance of this case to our appeal, this would imply that because the landowner can alternatively file an application with the DEP for disclaimers to confirm title of former sovereignty lands, that now somehow means that a quasi-judicial board can adjudicate proper boundary disputes. It is clear that these two issues are separate and distinct. Interpreting Gagnon this way forces a landowner to choose between filing an administrative appeal for the denial of a boat dock building permit or filing a declaratory judgment action regarding a boundary dispute. Respectfully speaking, if this panel upholds this dismissal of the two counts of our declaratory judgment based on administrative res judicata, this will establish a precedent allowing quasi-judicial boards to adjudicate property boundary disputes. This clearly contradicts with both Florida statutes and Constitution, which gives sole jurisdiction to the circuit court to adjudicate boundary disputes. The lower court's final order also states the following. As detailed within the amended complaint, counts 1 and counts 2 of the amended complaint raise issues which were the subject of a county administrative appeal and is the subject of a certiorari proceeding in a case pending with this court styled as Ginsberg-Klemmt versus WNCA, case 2006 CA 917NC. The county managed to convince the circuit court that the boundary dispute was the subject of prior litigation and therefore barred under the doctrine of administrative res judicata. Your Honor, Casanueva. Only last February, you reversed a dismissal based on res judicata in Thews versus Walmart. I would like to respectfully remind you, Your Honor, of the conclusion in Thews versus Walmart, which cited, because the face of the complaint does not demonstrate that the action is barred by res judicata, the defense should have been raised in an answer to the complaint, not in a motion to dismiss.
Can I ask you a question, please?
Yes, Your Honor.
Did I hear you say, with respect to your deck action, that count 3, the remaining count that was not dismissed with prejudice, is interrelated to count 1?
Well, in the sense, this declaratory judgment, count 1 and count 2, only has to do with this boundary dispute. It's related in that it has to do with the parking issue.
But are all 3 counts in your deck action interrelated?
I would say not. No, I would say not. Not at all. Because the third count has to do with a no parking prohibition along the Siesta Key Circle Road, which was initiated by a resolution and not an ordinance.
But does the parking prohibition, was that resolution made based on a determination of whether it was a 50-foot or a 30-foot radius?
I would say no, Your Honor. I would say that the first 2 counts are inextricably related and the third count lives on its own. I could have essentially filed 2 separate declaratory judgments, one having to do with the parking. Whether or not it's a 30-foot or 50-foot radius plays absolutely no role in the third count. I hope that answers your question.
It does. Thank you.
Thank you. So I ask you to also look at Neapolitan Enterprises versus City of Naples. That Neapolitan case is similar to ours. The second DCA stated that neither the circuit court nor this court decided Neapolitan's claim on its merits in the certiorari proceeding or determined an issue of fact or law in the administrative review. I assume this honorable panel is familiar with the 4 conditions of doctrine of res judicata. Number 1, identity of the things being sued for. Number 2, identity of the causes of action. Number 3, identity of persons and parties to the action. Number 4, identity of the quality of the persons for or against whom the claim is made. Again, Your Honor, Casanueva in Thew versus Walmart saw that factor at issue when it came to the identity of the parties. I quote, "For the purpose of res judicata, identity of parties is satisfied if the parties to the second action were either parties to the first action or in privity with those parties." Our action for declaratory judgment names Sarasota County as its sole defendant. In contrast, our petition for writ of certiorari names the WNCA as the sole defendant. The Board of County Commissioners were acting as the WNCA in denying the dock building permit. The WNCA is mentioned within the declaratory judgment within the findings of fact because Sarasota County brought in their county surveyor to the WNCA to testify before the quasi-judicial board. The WNCA is clearly not the defendant in the declaratory judgment, however. What would the WNCA have anything to do with a 30 versus 50-foot radius?
Part of the difficulty analytically in this case, for example, to borrow what you said, in your lawsuit, you file what are called findings of fact.
Correct.
Those are not findings of fact. Those are allegations of fact. Findings of fact are normally made by the trial court sitting in a non-jury position. And so when I look at your lawsuit and I try to decide what your cause of action, one of the rules of civil procedure calls for a short, concise statement of facts. And a lot of what you're doing sometimes reading your complaint is trying to guess what your cause of action is because some of the facts are not relevant to a cause of action. For example, you might be entitled to challenge in a deck action the county's imposition of a particular rule because that is a quasi-legislative function that allows for a deck action. But when you put in other things, it's difficult for a judge trying to figure out what is your specific cause of action. And when you relate it back to we were denied our permit, you might conclude logically that's what people are reading, to link back to the denial of the permit. So I know when I went to read your cert case and I went to read your lawsuit, for example, one of them alleges that you were denied procedural due process, that would be the cert case,
Right.
because you weren't allowed to cross-examine. And the next paragraph says, well, we weren't going to cross-examine anyway, we didn't prepare any cross-examination. And I'm saying, well, if you didn't assert it, what right was harmed? But again, these are only allegations that are supposed to be taken as true. But my concern is, if this goes back and you have had the right to plead a new count, you could add other counts, is that correct? Assuming there's no affirmative defenses of statute of limitations and the like. In fact, I note from the record, there is a second amended complaint filed, right?
For the deck judgment, yes,
Okay.
because he didn't, there was something about my index, it was.
Yeah, I'm just saying, there was something that's not here, because I went through the record to make sure.
Correct.
And I want to make sure I had the right lawsuit.
Yes, I understand.
Okay.
It does get complicated. And one of the reasons why, and I'm sure you're going to be hearing this in a moment, we are alleging that the quasi-judicial board did not use competent substantial evidence in coming to their conclusion, to their denial. Part of that competent substantial evidence argument does have to do with this calc sheet. It does have to do with the radius and the boundary dispute, but that's not the same as adjudicating the boundary dispute itself. So it sounds like we would otherwise be required to either not bring up the boundary dispute during the quasi-judicial proceeding at all, because that could be mixing up the issues. But don't forget, we were given this boundary dispute well after we had applied for our dock permit, and they're basing their denial heavily on this new information that we did not have before we even started our dock permit information. So that's why now we're going to get into, the parity of parties is one issue. I suppose, once again, it could be splitting hairs, and the county is going to say, well, he represented both the WNCA and the Sarasota County, therefore there's no difference in parties. But the WNCA has nothing to do with and has nothing to say about this 30 versus 50-foot boundary dispute. The only thing that they have to say is whether or not they're going to uphold that dock permit. I hope that makes sense. So that second condition for res judicata, which has to do with identical causes of action, they are alleging that we already litigated the boundary dispute in front of the WNCA. But the reality is, the first two counts of our declaratory judgment have nothing to do with that quasi-judicial denial of a boat dock permit, and everything to do with only the 30 versus 50-foot radius, this boundary dispute. The county commissioners, acting as the WNCA, never purported to be able to adjudicate this particular issue. They never even heard testimony regarding the calc sheet's validity. And even if they did, and this is a very important point, their only power was either to uphold or not uphold the denial of the boat dock permit. The WNCA does not have jurisdiction to decide where that cul-de-sac radius lies, whether it's in my petition for writ of certiorari with agreed there may be some issues or flaws in my writ. But even if in the writ I say this is bogus, it wouldn't matter. It can't be adjudicated in that avenue. The reason the boundary dispute
Should tell you're at 17.
I'm at 17?
Yes, ma'am.
I think I'm going to sit down.
Okay.
Thank you.
Good morning. May it please the court. My name is David Pierce. I'm Assistant County Attorney here representing Sarasota County, Florida. I'd like to start with the trial court's order in this case, which is on pages 394 and 395 of the record. And so the question that I would be asking if I were on this panel is, what did the trial court do? Well, the trial court indicated in its order that it limited its review of the amended complaint to its four corners, which is what's required under the Santiago decision by the Florida Supreme Court, cited in the brief. It's also what was required in the Hughes decision that Judge Casanueva wrote the opinion on in February of this year. So the trial court did exactly what they were supposed to do, which was limit their review to the four corners of the amended complaint and its attachments. And as you'll see in the amended complaint, there are reference to a large number of various attachments that are included in the record. So one of those attachments that is referenced in the amended complaint is Exhibit J. And Exhibit J, it's on page 340 of the record. In paragraph 18 of the amended complaint, there is this Exhibit J, which is the transcript of the quasi-judicial proceeding below, involving the denial of the dock permit. So the trial court, in limiting its review to the four corners of the complaint and its attachments, had the transcript of that quasi-judicial hearing. So it had that starting point to determine whether or not there was basically the same allegations in that quasi-judicial hearing as has been provided in the declaratory action that's the subject of this case. So at that quasi-judicial hearing, specifically found on pages 167 through 169 of the record, the Ginsberg-Klemmt specifically raised the issue of the sufficiency of the area for the two parking spaces. They also attacked the accuracy of the county survey on pages 166 through 169 and 177 through 183 of the record. That's during that quasi-judicial hearing. So that dispute was the central part of the reason for the board's decision acting as the Water and Navigation Control Authority in this particular case.
Let me ask you this. In looking at the complaint and the various allegations that are put there, including in one of them somebody walked out the room, somebody went in back the room, and all these which are arguably not statements of ultimate facts, if I can use that pleading word, did the trial judge exceed its discretion in dismissing with prejudice and not allowing and affording an opportunity to plead a cause of action that would not be subsumed within the certiorari proceeding, a quasi-legislative action, perhaps a takings claim, regulatory takings, or others? Should the trial court have just said, these are dismissed because your pleading is improper and it appears to be you are traveling under the cert case, you can't do that here, re-amend counts 1 and 2 to see if you can bring them into a separate standalone? And
I think that's what the trial court tried to do in this instance, Your Honor, by leaving count 3 alone. Okay. And count 3 dealt with the parking resolutions. It says counts 1 and 2, those specifically deal with this boundary dispute that you argued at the quasi-judicial hearing involving those particular surveys. Now, could they amend and allege some sort of takings claim? Possibly, but they would have to wait until the certiorari proceeding was over with, because you cannot pursue.
It's not final yet.
It's not final yet.
There might be a use available, but you won't know until that's done.
Right, on the Key Haven decision.
Could you not plead the deck action and then have it stayed or abated?
You could.
Because we're talking about whether it's abuse of discretion to dismiss with prejudice or not. So are you agreeing that she could plead a deck action, but it would then be abated?
She could, for assuming for a constitutional claim, for takings or for a facial challenge to the ordinance.
Legislative action, constitutionality of the statute.
Absolutely, they can do that, but that's not what counts 1 and 2 were.
Perhaps a statutory claim?
Perhaps a statutory claim. So any of those things, and that's the distinction between, a lot of these cases is which sorts of constitutional claims can be resolved through a quasi-judicial proceeding and certiorari versus a declaratory action. Facial constitutional claims are deck action only. As applied, must be resolved through certiorari, and that's why the Snyder decision, some of those other decisions say those particular remedies, as applied constitutional challenges, go to the essential requirements of the law, that second prong of certiorari review. So could they potentially plead, some other cause of action, some sort of facial constitutional claim some sort of allegation of a taking, certainly they can, but that's not what the subject matter was of those first two counts.
Well, you know, the reason I asked that prejudice claim, because the order says you can dismiss, count 3 is dismissed, but I guess you could argue that the last sentence of the order has 30 days to file a second amended complaint as not being a limitation of causes of action, but rather an avenue to plead all your proper causes of action.
That's correct.
Whether it's count 3 and new counts or otherwise.
That's correct, Your Honor.
Okay.
That's the way I read it. So, and looking back at the amended complaint as well, within the four corners, there's not just that paragraph 18 that references the quasi-judicial decision and through the attachments, there are specific paragraphs within the amended complaint that reference the quasi-judicial decision and reference the certiorari action that was currently pending. For example, on page 342 of the record, paragraphs 24 and 25 of the amended complaint, there include allegations, and the following allegations is on paragraph 24, all parcel maps used by Sarasota County Property Appraiser, Exhibit A, and all aerial images and aerial maps used in the county, Attorney Pierce's response to the writ of certiorari, case 2016 CA-00917-NC, and in the WNCA Administrator's presentation before the Sarasota County Commission show the 30-foot radius at the terminus of the Siesta Key Circle reflected in the recorded subdivision plat map. So Judge Eiten, when he's reviewing this amended complaint, he sees there in paragraph 24, there is a parallel certiorari proceeding that's raising similar issues.
All parcel maps and all aerial maps in response to the writ certainly have the case. That's what we're referring to in 24?
In 24 and then 25, they talk about to arrive at a 50-foot radius, Sarasota County relies on the validity of an unrecorded document, and they talk about in that particular paragraph the so-called calc sheet, which was, at issue a dispute during the quasi-judicial hearing, and they also reference that case number again, which is the certiorari proceeding. So you've got paragraph 18, paragraph 24, paragraph 25, paragraphs 37 and 38 on pages 38 and 49 of the record, where they talk again about the certiorari case. Paragraph 38 specifically talks about, and I'm paraphrasing from just the one sentence in paragraph 38. In this case, the unjustified usage of the unrecorded information would be a decisive factor concerning the life or death of a boat dock. It would cripple the usable size of plaintiff's uplands parcel from 1,541 square feet to 393 square feet. That's an admission within paragraph 38 of the amended complaint that the central issue in dispute regarding their dock permit application was the area in which they could possibly have parking.
Your argument also illustrates another difficulty in its complaint. The very paragraph that you cited, paragraph 25, reads in part, nevertheless, County Attorney David Pierce does not hesitate. That doesn't strike me as a proper subject of a pleading. There's extraneous stuff in these paragraphs that arguably, I'm telling you wrong, ought not to be there in order to state a proper cause of action. It makes it hard to differentiate what is the cause of action.
I would agree with you, Your Honor, but in looking at it in totality, I think if you are the circuit judge and trying to determine, well, what is it that's being alleged here, and how does this differ from a cause of action that would travel up through certiorari, why can they not bring the same allegations and arguments regarding these calculation sheets, the sufficiency of the survey? Why isn't that something that an issue that could be raised through certiorari review?
Well, would the decision by the county to adopt a particular survey or to adopt a rule saying we're going to use calc sheets, those would be what a quasi-legislative decision, would they not? At least on its face. Because you are applying them in the case to deny the permit, which means evidence is done, that becomes quasi-judicial.
Yeah, I think...
Because there are certain things that are quasi-legislative what a county does.
Yeah, I think
those are subject to a DEC action.
Yes.
For arbitrary capriciousness and that type of challenge, right?
Yes.
So the art form is how you plead it.
That's right. So the question is, is the surveyor, county surveyor's decision to use calculation sheets, to use monuments, to use the plat, to use other surveys. I don't know that that's a quasi-legislative decision. That may be an executive decision as to what she uses in creating her
Again,
particular.
you have to figure out what constitutes and how to plead it.
That's
But
right.
I'm just saying, there's certain things that you have rules that generally are considered to be, we're gonna do this. Then when you apply them to evidence, you move into the quasi-judicial aspect.
That's right.
Which goes up by cert.
That's right.
I don't profess to be an expert in that area, but I'm trying to make sure I understand all the rules of the road.
Sure. So we have paragraphs 18, 24, 25, 37, 38, paragraph 40, on pages 349 and bleeding over to 350. They mention, in its response to the petition for certiorari, defendant writes, George F. Young, a civil engineer and surveying firm, prepared the sales plat in 1925. They also provide the calculation sheet to the county survey office. So again, that's another reference to back to that same allegation. There's also in paragraph 48, page 351 of the record, paragraph 58 on pages 355 and 356 of the record.
Let me ask you this hypothetical. With regard to the calculation sheet, the application within the confines of a particular application may be quasi-judicial, saying having to be inserted. Can it also have a second counterpart? I seek to challenge the legal determination made by the county commissioners that authorizes the use of it, perhaps by ordinance, and when that would maybe fall under the rubric of quasi-legislative. Again, I don't know how one pleads it, but I'm trying to say, I guess the question is, can it be both? Can it have a foothold in both areas?
I don't think so in this instance, because you're talking about, essentially, it
The
was
way
expert
it's pled,
testimony.
it's how it was used in the case.
Right. This essentially what the county surveyor provide at the quasi-judicial hearing was expert testimony, say, this is my survey. This is what I relied upon in providing my particular survey. So it's basically, it's expert testimony in support of staff's
And not necessarily
determination.
an action by the government. It's just the actions of the witness.
It's the actions of the witness. So I wanted to spend a little bit of time talking about that Gagnon decision. And I think, the trial court properly relied upon that decision, as a decision of this court from 1999. And yes, there is some discussion of section 26.012 of the Florida statutes, which grants exclusive original jurisdiction involving title and boundaries to real property to the circuit court. But this court, in Gagnon, said, quote, we conclude that a quiet title action in the circuit court and an administrative application under Rule 18-21.019 are alternative remedies available to the owner. So what did you have happen in this particular instance, in this case? You had a staff-administered permit, a dock permit, that was the subject of an appeal to the Board of County Commissioners sitting in its quasi-judicial capacity. Okay? The record reflects that the Ginsberg-Klemmts knew they had the option of filing a separate declaratory action, and yet they decided, no, we're going to file an administrative appeal to the Board of County Commissioners. And so the remedy from a quasi-judicial decision of the Board of County Commissioners is certiorari. Okay. Now, if I think that the trial court correctly interpreted Gagnon is that there is that particular option. Could you, to have the county go through the process of issuing a determination on whether to grant the permit or not, then handling an appeal, an administrative appeal to the Board of County Commissioners sitting in its quasi-judicial capacity, then to have a certiorari petition filed dealing with that same subject matter, and now to have a separate declaratory action regarding that same decision, how is that, a proper use of both the county resources and then the circuit court's resources to have them duplicate the same arguments that they raised at the quasi-judicial hearing? Why can they not raise those arguments in a certiorari review as opposed to a separate declaratory action. Is there a possibility? Could they plead some other causes of action associated with a second or even now a third amendment complaint? Possibly. But that doesn't mean that the circuit court erred into saying counts 1 and 2, no. Those are the same things that are basically intertwined with the board's quasi-judicial decision, and that remedy is through certiorari review. You already have a certiorari petition. Thank you.
I have my 3 minutes.
Yes, ma'am.
This is the part that's a little more difficult. I'm not exactly prepared, but what I need to say is this. All of this discussion of, could it have been a constitutional, could we call this a taking? No, folks. The map, this boundary dispute that you see here, that was only first brought out in front of the county commissioners. They cannot decide. He just admitted, well, our expert came and that's what she drew. So it must have been adjudicated by the county commissioners. It was not adjudicated, and a very important point, they cannot adjudicate that. If you guys, I'm sorry.
It's okay. We've been called worse. I hear you struggling to find some other possible remedy for us. Maybe there's some other forum, some other avenue. I'm telling you, there is one avenue. It seems pretty clear that there is a boundary dispute. They admit that there's a boundary dispute. He is trying to say that it was tried in front of a quasi-judicial board. It wasn't.
There's a boundary dispute as a result of a hearing officer deciding against you, correct?
No, there's a boundary
Finding it's 50 instead of 30.
Sorry, they did not determine that.
All this litigation spawned from that.
The boundary dispute arose from our application for a dock permit, not from the decision whether they decide to get a dock or not. They did not decide on this boundary dispute. They decided that particular dock permit was not allowed, and it could have been for a lot of other reasons. You didn't see, thank goodness he didn't bring up any more of the cases. Environmental issues.
But wasn't the issue of the boundary of the radius determined during the dock hearing?
It was never determined, Your Honor.
But they adopted
They
the calc
looked at
sheet.
it and they've denied they didn't even say why. They listened to the testimony of the county attorney. Do you think my surveyor was allowed to come and speak? Do you think anybody saw the original calc sheet that this is based on? No. I've seen that calc sheet. It's not signed. It's not, they don't even have the original. It's a copy of something. I have so much proof that it is not a 50-foot radius, and nobody has looked at that proof. I've worked hard to get that proof. I want to be able to litigate this. You see, whatever you choose right now, and I walk out, and you determine that it's a 50-foot radius, they have taken my land, and there's nothing I can do about it. It was not determined by a quasi-judicial board, and it cannot be determined by a quasi-judicial board. And Gagnon, again, him bringing up Gagnon. Gagnon is very specific. If you rule in his favor, again, it implies that that quasi-judicial board can decide next time somebody's going to come out with a permit and they go, I don't want them to do that. There's too many millionaires living around there. Let's quickly figure out a way that we can stop them and bring out this information. And they'll go, oh yeah, he's their attorney on top of it. He's the one that advises them how to rule. I need to be able to adjudicate this in front of a proper court. By you guys allowing me the possibility to do that, I get to start really fighting my important fight, which is for my land.
Your time has gone
you.
by a little bit. Better let you go. I thank you. I thank you both. Have a safe journey back.